Sir. Yeah.
We have two cases. Cause number 24 CR 559. That's a motion to revoke unadjudicated probation, and a new case 25 CR 1332. Second degree felony of indecency with a child by sexual contact, and the defendant was on probation in the earlier case 559 for the third degree felony of, looks like,
Injury to
injury to a child. Does the defendant waive formal readings of the motion to revoke unadjudicated probation in 559 and the indictment in 1332? Can we proceed in summary?
It is, sir.
Set them up numerically. In 24 CR 559, there's a motion to revoke unadjudicated probation. In each of these cases, the defendant waives formal readings of the charging instruments, and we can proceed in summary.
Yes, sir.
Mr. Andrews, raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Lower your hand. You are Kendall Dewan Andrews. Yeah. In this motion to revoke unadjudicated probation 24 CR 559, in summary, this alleges that on March 27th, 2024, in this criminal district court of Jefferson County, Texas, you were placed on deferred or unadjudicated probation for 10 years for the offense of injury to a child younger than 15 years of age. You understand? Is all of that true and correct, sir?
Yes, sir.
What are we pleading truth?
Yeah.
One is
Indecent.
the indecency, which is represented by the new indictment 25 CR 1332.
Yes, sir.
Allegation one states you committed the offense of indecency with a child by sexual contact on or about May 9th, 2025 in Jefferson County, Texas, which is a violation of condition one of your deferred or unadjudicated probation order, which states that you shall not commit any offense against the laws of Texas, the state, or any other state or the United States. Is allegation one true and correct?
Yes, sir.
Are you pleading true and correct voluntarily and because it is true
Yes, sir.
as it is alleged? Correct? It's true as it is alleged?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation
Yes, sir.
by a preponderance of the evidence or greater? Your probation can now be revoked. You can be found guilty and sentenced up to the full range of punishment for this third degree felony, which is no less than 2, no more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
There is an agreement that's been reached in this case where you would be pleading true, found guilty, sentenced to 10 years in prison.
Yes, sir.
This would run concurrently with the sentence that is going to be assessed and a plea of guilty you're going to be entering into in the next case, this second degree felony of indecency with a child, 25 CR 1332. Is all of that true and correct?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Yeah.
Hold on, everybody. I'm going to try to erase something off the pad and using this stylus that anything can happen when the stylus touches this pad.
Glad to hear it's not just on me.
All right, I am going to follow this agreement. Anything to add before I make findings here on this case?
No, yeah.
Anything you want to say, Mr. Andrews?
No, sir.
If not, I'm going to find in this motion to revoke unadjudicated probation 24 CR 1559 that you were placed on probation earlier in this case on March 27th, 2024 in this court. I find you are pleading true to allegation number 1 of this motion to revoke probation, committing the offense of indecency with a child,
Yes, sir.
as we have placed into the record. That is supported by your voluntarily and knowingly made plea of true to that violation, admitting it. That is enough to grant this motion to revoke unadjudicated probation by a preponderance of the evidence or greater. This motion is granted and your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty to this third-degree felony of injury to a child, causing bodily injury to a child younger than 15 years of age. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at that hearing initially to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the third-degree felony of injury to a child. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. Do you understand what has happened in this case, sir?
Yes, sir.
We now go to 25 CR 1332. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment handed up on September of 2025 alleges that on or about May 9th, 2025 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child, bisexual conduct, namely touching the genitals of the child, a person younger than 17 years of age. Do you understand what you are charged with here?
Yes, sir.
I believe the child was 10 years of age at the time of this event. Is that correct, everyone? That's what this alleges in the probable cause affidavit.
That would probably be accurate, Judge.
If convicted of this crime, this is a second-degree felony, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
It is accurate, Judge.
An agreement has been reached where you would be pleading guilty, found guilty, sentenced to 10 years in prison to run concurrently with the preceding case that you were placed on probation for, was revoked and sentenced to 10 years a few moments ago. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you will have no right of appeal of your case. Do you understand?
Sir.
How do you plead to this second-degree felony of indecency to a child with contact?
True.
Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1 in this case. Did you sign that document, understand it, discuss it with your attorney?
Yes,
Are the
sir.
contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
Okay.
without objection if needed. This states, among other things, you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report this way.
We waive that.
I'm going to follow this agreement. Anything else to add by any party?
No, yeah.
Not, I'm going to find that Kendall Dewan Andrews, Dewan Andrew, am I pronouncing your middle name?
Dewan.
Dewan Andrews, you are pleading guilty to the second degree felony of indecency with a child. Voluntarily, knowingly, intelligently, there's sufficient evidence supporting your guilty plea from State's Exhibit 1 to find you guilty beyond a reasonable doubt. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
I now find you guilty beyond a reasonable doubt of the second degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison to serve a term of 10 years. And this sentence shall run concurrently with the preceding cause number 24 CR 559, the probation of the injury to a child for which you were just a few moments ago revoked off of your probation, found guilty, and sentenced to 10 years. These will run concurrently. Also, this indecency with a child is an offense under the state of Texas laws, which require you to register as a sex offender under the sex offender registration program in Chapter 62 of the Texas Code of Criminal Procedure. Do you understand you have responsibilities to comply with that part of the law? Failing to do so is a criminal offense that may result in prosecution. If you move to another state that has similar reporting requirements for sex offenders, you must register in that state. Failing to register would result with you being charged with a criminal offense. I'm looking at a document that looks as though you've signed this and your attorney has acknowledged that he's discussed this with you. Is all of that true and correct?
Yes, sir.
All right. This is made a part of the record as well. It's called Sex Offender Registration Admonishments. And you have continuing duties under this law to perform responsibly. Do you understand what has happened today, sir?
Yes, sir.
God bless you. Just 1 second, please. You were 22 years of age now, correct, sir? Is that right?
Yes, sir.
Okay. One thing that this court is just going to add as, I guess, an additional footnote on this, each of these children were 10 years of age at the time they were sexually assaulted by the defendant. These were your children too, correct? No, they were you foster your the child's mother you were married to or had a relationship with?
No, sir.
Okay. What was the relationship these children were to you?
Cousins.
I'm sorry?
Cousins.
They were as part of your family though. But they were family members, right?
Yes.
They weren't just strangers, they were family members.
Yes, sir.
And you are 22 years of age, correct?
Yes, sir.
You were on probation for the injury to a child, which was a sexual assault of causing bodily injury by touching the anus of the little child. And I read the probable cause, and you were you invaded the anus with of the innocent child with your finger. And then here, this indecency where the child is touching the genitals of the child. And these are both these were both 10-year-old children. There's probably no worse of a crime than the harming of a child and the sexual exploitation of a child. Not just one, you got two here. And this is all too often happening of cases in this courtroom. I don't know what the problem is, but it will be dealt with severely. The state is very vigorous in prosecuting this. There's no one that has any sympathy with someone who harms a child. No one. The children really are almost defenseless when they're 10 years of age or an adult took on them, come along and assault them. And from what we all know, it's not like they can forget about it. A 10-year-old can remember. I remember when I was far younger than 10 years old of important events that affected us emotionally. So this child isn't just victimized once. I'm sure she will relive this horror maybe most of her life. So you will be victimizing her maybe all the rest of her life. Can you think anything worse than that? No. Well, it will be dealt with severely. The law states it shall. The state's pretty vigorous, and this court will continue to be very aggressive and just. But justice when you harm a child is severely assessed. Do you understand?
Yes, sir.
That is all. How do you give back the innocence of a child?